Welcome to the Property Management Law Solutions Podcast. Your host, Attorney Tim Baldwin, will guide you in all things property management, law, markets, politics, and commentary. Your property is his priority. Here's your host, Attorney Tim Baldwin.
All right, hey everybody. Welcome to the Property Management Law Solutions Podcast. I am your host, Attorney Tim Baldwin, and today we're going to have a conversation with Mark Nicklow. Mark is one of our newest attorneys at our law firm in Pensacola, and I'm really excited to have Mark here.
Thank you, Tim.
Mark is a great fit for Property Management Law Solutions. You know, we handle a wide variety of things for landlords, property management companies, investors, and so when we were looking for another attorney, came across Mark, and he's been a great addition. So I thought, well, it'd be great for the people to get to know Mark a little bit, and really for us just to have a great conversation about some of the things we do every day.
Yeah, absolutely. I look forward to it. I'm very excited to be here.
Yeah.
And you want me to jump in and
give you
a little bit of my background?
Yeah, tell the folks a little bit about yourself, and we'll jump into some interesting topics.
Sure, that sounds great. So my name is Mark, as he said. I prefer that you just call me Mark and not Mr. Nicklow or anything formal like that.
That's only for your dad, right?
That's. I don't even think he goes by that, to be honest with you. But I started my legal career at a firm called Lutz, Bobo, and Telfair. They handle a lot of landlord-tenant actions, mostly in the manufactured housing industry, but also in some commercial apartments. RV industry is big. And I did that for 2 or 3 years, and then was asked to go in-house counsel with a private equity group that owns rental properties throughout the eastern side of the United States, from North Dakota down to Texas, all the way over from Maine down to Florida. But a bulk of it was here in Florida, probably about 60 properties here in Florida. Mm-hmm. And Florida does a great job, and that's what I found, of kind of differentiating between the different types of landlord-tenant occupancies. With mobile homes, if the tenant owns the home, we have a statute for that. If it's an RV park and they're transient, under 6-month residency, we have a statute for that. Yeah. If they're just your standard landlord-tenant, we have a statute for that. Yeah. And it breaks it down between commercial and residential and even storage units. So really exciting stuff.
Yeah. No, Florida is I think, advanced as far as the legislators seeing the variety of business interests, occupancy interests in Florida with the variety of housing or recreation that we have here.
Oh, absolutely. And the governor himself has pushed it, a few years ago with the Live Local Act. Yeah. We're trying to push more affordable housing to incentivize investors to come in. Yeah. Kind of restricting the what local government can do as far as restricting their build outs in different areas. So Florida is definitely a great state for this. As I said, I kind of oversaw communities in different states, all different states, and Florida statutes to me are hands and feet above everybody else. Yeah. So. Yeah.
Yeah. Well, yeah. When I'm licensed in Montana as well, but when we're looking into other states, and getting into practice there, and as I look at the statutes, and I say, well, I really appreciate Florida because not only do we have these variety of topics covered, but I think the statutes are drafted pretty well.
They're very well worded, and they're very clear and concise, in my opinion, and they cover they try to cover as much as they can in the statutes, as opposed to leaving it vague and open and open for interpretation, so you don't get a different opinion from one judge from one county to the next.
Even though we still do.
We still do, of course we do, because judges do what judges do.
Right.
But there's little room for interpretation here in Florida. They do a very good job of clarifying what the rights are.
And they let the parties contract sort of the rest of the relationship, which is good. I think it's good for landlords, especially because landlords have different ways of doing business. Granted, not all of them are great, but a lot of them really are, and these contracts actually allow them to develop systems of operation and different revenue streams and these types of things. So
absolutely, and your contract, your lease,
Yeah.
it is a contract. I always refer to it as such because it's two parties agreeing to the terms.
That's right.
And most courts will interpret that as this is what you agreed to. So this is what you have to follow. In Tim's lease itself that he provides on his landlordhotline.net.
Or if you're a client, you can get it just directly from us,
Covers almost every thing you could want, and
Yeah.
you're really able to pick and choose those terms that you desire to have in your lease, but you can also just take what he throws in there.
Well, finishing up your experience, sort of wrapping that up. I mean, you have a wide variety and a wide range of experience in helping landlords, which is exactly what Property Management Law Solutions is all about. So that experience is great. So let's sort of get into that a little bit of I think we mentioned before the podcast of what's sort of the area that you think would be of great interest to people. And we talked about the RV parks and the mobile home parks. So I know you have a lot of experience in both of those. So let's pick one. Which one would you like to talk about first?
So let's talk about the mobile home parks, because
great.
it's the more I say complicated, but it's the more there's more substance to it with the mobile home parks, and that's because there's different regulations. You can rent the home, you can rent the mobile home to the tenant, and then you fall under the standard landlord-tenant statute. But if they own the home, they could fall under the mobile home statute. And there are different regulations for those. There's different administrative burdens when you do move into that Chapter 723, which is the manufactured housing statute. And it really creates more rights for the tenant. And the reason for that is simple. It's because they own the home. They own this property, this house, this structure that's on your property. So you're leasing the lot to them, and they own the home. So they have to be afforded more rights.
And that makes sense.
Yeah, no, absolutely. And there's Department of Business and Professional Regulations, or DBPR, oversees what's called a prospectus in these mobile home manufactured housing communities, and that regulates everything you can do, including rent increases.
Right. Well, a lot of comparing, just the landlord-tenant statute with the mobile home statute. Notices are different. They're similar but different. Typically, you need more notice when you're dealing with a mobile home lot owner or resident. Speak to that a little bit, as if there's someone out there listening who's thinking maybe I want to get into investing into mobile homes. So sort of give us a contrast of the differences.
Oh, absolutely, yeah. So even just with the notices, as Tim pointed out, so if you're gonna send a notice or a demand for rent, it's a 5-day notice as opposed to a 3-day notice. But you also you have to post it on the door or hand deliver it and mail it certified, which adds an additional 5 days to that, excluding weekends, holidays. There's all these different requirements.
The administrative rules kind of kick in a little bit there too.
Absolutely, and it's just to give them more time. Give them more time to pay. Give them more time to keep possession of their personal property, which is the home. I will state again, I said it's a structure, I said it's a home. In the state of Florida, statutorily, it's personal property.
Right, like a vehicle.
It's a motor vehicle, and it's actually regulated under Department of Highway Safety and Motor Vehicles. There is a VIN number for the home. They are expected to have a title and registration, and they are supposed to, most of them don't, but they are supposed to keep that registration up. There are benefits, though, as you mentioned, for investors who are thinking, hey, maybe I want to buy a mobile home park. There are a lot of benefits to that. Mainly, there's low maintenance and upkeep, because you don't have to, as a landlord, fix anything on their home.
Right.
That's their job. That's their responsibility because they own the home. Rents are typically lower, so you're going to collect less each month, but there's less, as I said,
less
overhead.
cost.
Less cost and maintenance there. So you're just kind of bringing in that lot rent each month, and the tenants are paying.
Would you say, in your experience and looking at the market, that there's an increase in interest in mobile homes as opposed to maybe multifamily or single family?
Absolutely, and I mentioned this to you yesterday. I mean, that kind of started. Warren Buffett with Berkshire Hathaway couple years back said, hey, this is a great industry to be a part of. He owns, I think, Clayton Homes, which is a manufacturer of mobile homes, and a couple other companies that he invests in. But it's just profit. It's pure profit. It's a long term. It's not a short term.
Yeah.
You're not gonna jump in this and make all your money back overnight.
Yeah.
But
like pretty much anything else.
Right. But long term, it's recession proof.
Yeah.
Because everybody needs housing, right?
Yep.
Everybody has to have housing.
And affordable housing is obviously becoming more and more of an issue. You see tiny homes that's another thing that we're going to see a lot more of these tiny homes, which right down the road from us where we are right now, downtown Pensacola, there's these little tiny homes. And I never would have thought, because downtown Pensacola, for those who don't know, if you don't live here, downtown used to be kind of like sketch, like it wasn't really a great place to invest in necessarily, but we've made a lot of progress. I mean, we got the Wahoo State, the baseball team right down the road. We got a lot of development downtown. It's a great place. Great people love it now. So I would not have thought tiny homes, and a friend of mine actually just developing that. He's doing a great, I would imagine his return is going to be pretty significant considering location.
You would assume, so with the tiny homes, it's actually funny that you mentioned that, because a few years back when I was working for Lutz, Bobo and Telfair, as I mentioned, my boss was the general counsel for the RV Association, FRVCA, which I know is a weird acronym for for an RV association, but so they regulate the tiny homes at the moment.
I didn't know that.
But there's a group that have been trying for years to get a separate statute just for tiny homes, because they don't want to fall under the same statute. But because most of the tiny homes are on wheels, a lot of them are. Now, you can build just a structure
on a slab,
but most of them are mobile. So they fall under the guidance of the RV statute.
Wow.
At the moment.
Good to know.
Yeah, and definitely keep looking at that every session, which is typically January through March or February through April, sometime around there. But just kind of watch those regulations, which is one thing I really enjoy, and I enjoyed it when I was in-house counsel, kind of 50 different states, looking at all the.
You got to know a lot when you're in-house for a large company.
Absolutely, yeah. It's kind of creating a chart of all the different statutes, where to look for different regulations, whether or not a state has, like Florida, different statutes for different types of communities, different landlord-tenant statutes, things like that.
So the difference, and we look at investors who are looking at, mobile home parks, because that's sort of the topic we're trying to stay on, I guess, is, there's the development of the lot. So you have these costs that you wouldn't ordinarily have with a single family. So there might be a little more upfront investment to get that lot ready to house however many lots they're going to put on the property. Have you seen issues or problems with developers as they're trying to get these lots developed for mobile homes?
Well, so we mentioned kind of developing the properties. Most investors come in and they buy mobile home parks that are already established. I had one client who was adamant about, hey, I'm going to develop my own. I'm going to build my own, and there's a little bit more regulation over that. And then who's going to bring the homes in? Because a lot of the times the tenants, the residents, just want to buy a unit that's already on site. So then it's up to the investors. So there's the overhead. I'm going to purchase all these mobile homes, all these units, and I'm going to put them on the lots, and then I'm going to sell them. Which is a good. I get it. A good investment if you can recoup all that money you spent on the homes. But that's kind of the overhead. The initial upfront overhead is there. Absolutely. And you're developing these lots. You got to put the slab down. You got to put the piping, the plumbing in. You got to decide whether we're going to connect to the city sewage and plumbing, or if we're going to have our own septic system or. Whatever it may be. It's a sewage treatment facility, typically with these mobile home parks. It's not an individual septic system, because that would create all sorts of problems.
Absolutely.
Which you still see. And I've seen plenty. As we kind of mentioned before, going back on my experience, I've done everything from code enforcement hearings up to class action lawsuits. And code enforcement is when you get into these issues with plumbing, because the city comes out and inspects and says, well, this isn't up to code, we're going to start fining the property owner, even though it's something maybe that the tenant did. And then we argue those. We argue those with code enforcement, and we say, no, this was the tenant's responsibility.
Now, do you see typically in leases with the mobile home owner, clear-cut this is what you're responsible for, this is what we're responsible for, and not having those forecasted issues, if you will, can cause a lot of problems, right? A lot of disputes.
Absolutely, but that's what the prospectus is actually for. This regulates who's responsible for what. Typically, with plumbing, for example, it's everything above the ground is the tenant's responsibility. Everything below the ground out to the main line is the landlord's responsibility. And that's what a prospectus does. It kind of regulates those and it really just sets in stone, hey, this is your responsibility, this is mine.
Yeah.
This is what I can do, this is what you can do. This is what you're responsible for, this is what I'm responsible for.
It is so important. I mean, in fact, I had an interview, I'm going to be on the podcast here coming up in October, and it's with a large podcast, and so, you know, she wanted to learn about me, right? So we're having these discussions. So she asked me, she said, what do you think is like the most important topic for investors to learn about?
Yeah.
It's a great question, you know.
It is.
And I said, sort of without even having to think about it, I said the lease agreement.
Yeah.
By far, 100%. Because that is your business document. That is what governs everything.
It's a contract.
With the tenant.
It's a business contract. It's a contract between me as the landlord and you as the tenant that says these are the terms.
And if you don't have, I mean, a wide variety of issues addressed in your lease, it's going to happen. You're going to have disputes.
Yeah.
You're setting yourself open for liability. Whose obligation is this? You think it's theirs, they think it's yours.
Yeah.
There's disputes. Okay, you bring in attorneys, you fight over it. Sometimes you get sued. You know, all because what you just simply didn't have the right lease.
Yeah.
Same thing with mobile homes.
Oh, absolutely. Luckily, DBPR requires the prospectus to be filed. Most of these parks that are already established have one.
And then to change them, you've got to go through quite a process, right?
It is quite a process. You can either change it or you can create a new one. However, once a tenant has that prospectus, that's their prospectus. You can modify it, you can alter it, but you have to send them a notice, and then they're given an opportunity to object to that notice, to that change to the prospectus.
Now, who governs the dispute? If there's a dispute with the tenants and the landlord, prospectus change, what happens?
Well, first they have to file their objection or send an objection to the landlord, and then they attempt to sort of mediate that. There are requirements in the statute that said, hey, we have to have a meeting about this. Tell me why. And this typically occurs with rent increase notices. Yeah. Because that
hits the wallet.
That's where people object.
Yeah.
They say, okay, well, we think that your rent increase is unreasonable. So what happens is the landlord sends a notice out. The tenant then objects to the notice and says, well, what's your reasoning for the increase? So then you have your first meeting. In the first meeting, the landlord says, this is why I did it. And there are strict regulations under Chapter 723 as to how and why they can increase it. Most of the time, it's just, hey, this is what the rent is in the area. Market rent. Yeah, market rent increase. That's all I'm doing.
Yep.
However,
so that's a legitimate reason for mobile home owners as well.
But they have to prove it.
Yeah.
And that's what's wild is you have to prove it to the tenants, to the homeowners there. You have to say, well, the rent over at Mobile Home Park 2 is this amount. The rent at Mobile Home Park 3 is this amount. So and we think they're comparable to what we have.
That's fascinating because there's got to be a first person, right?
Yeah.
To change.
Oh,
right?
Absolutely.
So if no one's done it yet and you're in that local area, wherever you are,
how do you do it?
How do you do it?
Well, you look at other markets. You say, okay, well, the apartment complex over here is charging this much. And while you own the home and we own the property, they're not offering what we're offering. We have a community center. We have a pool. We have all these. It almost becomes like a condo association. Right. And you kind of look to those as well, or you may look at just a house rental. Yeah. What does a house rental cost? And you want to get close to it, right? Right. That's the idea, and you offer up all these comparable rents, market rents, and then the tenant requests a second meeting if they still disagree with you. Okay. And at the second meeting, they present their findings. They say, well, no, but the community over here, which we believe is more comparable, Mobile Home Park 4, because they have a pool and they have free lawn service, and they have all these things that we offer, right? And their rent's $100 below that, below what you're trying to change it to. Right. But as you said, somebody has to set the market. Yep. So the idea is, and after that second meeting, there's a third mediation,
Right.
is what they change it to. So that's where the two sides come together and they try and come up with a resolution before filing a lawsuit. And then the homeowners are allowed to file a lawsuit.
Gotcha.
Now,
so if you still can't come to terms after that mediation, somebody has to, right? Because if you're at a deadlock, you're at an impasse.
the rent's the rent. The landlord did his statutory obligated notice.
Okay.
This is the rent. That's it.
Okay.
So throughout any potential lawsuit, the tenants are required to pay that increased rent amount.
Okay. But they can still challenge it if they'd like to.
They can absolutely challenge it. It's going to cost attorney's fees for both sides.
Sure.
The homeowners will have to take one of two routes before they can even challenge it. Is they form either a homeowners association, mobile home park homeowners association.
Like a tenant association.
Yeah,
kind of thing.
it's all under the guidance of Chapter 723.
Yep.
Or they get a majority signatures.
Okay.
And they form, and I forget what it's called, but they form essentially an association without the corporate, without going to DBPR and creating a business.
Gotcha.
Creating an LLC or whatever it may be.
Yeah.
But the reason they don't want to do that is because then they're obligated, right? They're liable for any damages because the statute allows attorney's fees.
Yeah.
So if they lose the lawsuit, who's going to pay for that?
Yeah.
Who's going to pay the attorney's fees for the other side?
Yeah.
And we are going to win.
Yeah.
That's good.
That's good confidence, Mark. I like it.
Yeah. We're gonna win or we're gonna settle, right?
Yeah.
And that's the guidance.
That's it.
If I think I'm gonna lose, I'm gonna do my best to advise my
When you were talking, I thought there's an issue that I don't know if you've ever seen it before, but it certainly came to mind, and that is when you have mobile home park owners who are maybe going through this process, they want to, and perhaps all of them want to. Perhaps they all want to increase or whatever, and show market increases.
Absolutely.
And then they collude together. Like, hey, guys, let's do this. Antitrust. Is that an issue? Have you seen that?
I'll tell you, and this is actually pretty wild because there was a publication, and it's still in existence, that publishes all the rents in different areas.
Okay.
So
wow.
Yeah, it's a book that comes out annually. I think it's annually or biannually, something like that. I can't remember the name of it again. Yeah. And I do apologize for that. So they released this book, and it just shows what the lot rents are.
Interesting.
For the area, for the different mobile home parks.
Wow.
And
that's fascinating.
Someone sued the publication.
Antitrust? Yeah.
You got it.
Everybody's just going to keep trying to match where the highest point is.
Right, but they're saying, obviously they threw their hands up. No. This is just information.
Yeah.
This is publicly available information or privately available information because I can call up an apartment complex. I say, hey, what's your rent on a 2-bedroom home?
Yep.
I can call up a mobile home park and I can say, hey, what's your lot rent?
Yep.
So the
idea here is that the market's telling us. So I'm looking at the information. I decide as the lot owner.
Yeah.
Where am I going to go? Do I want to be below my neighbor?
Sure.
Do I want to be above my neighbor? Am I trying to distinguish myself from the next park?
Yeah. And again, as you said, who's going to set the market? Maybe I'm going to go $15 above my neighbor because the market. He changed his rent 6 months ago. 6 months later, the market is $15 higher. I believe it's $15 higher.
Yeah.
And it's a risk reward. Obviously, you have to assess the risk in raising your rents a certain amount. I've been involved in several class actions where the homeowners did form an association, but I've also seen some where they just kind of, it's okay.
Yeah.
We can accept that. The market is what the market is. And maybe even go through those first and second statutory meetings. And they still decided it's just not worth it. We're going to spend too much money on attorney's fees to go through that. So it is a good industry. It is growing. There is the issue of, hey, it's a trailer park. That's what people want to call it. I call it manufactured housing community or mobile home park. Trailer park is what people know it as. And
it's the subtle, the connotation is a little different. Yeah.
Absolutely. Yeah. But
and that's why probably somebody said, hey, let's call this a manufactured home park.
Well, that's what it is. It's manufactured housing. That's the industry because they manufacture these homes.
Right.
But you do get the trailer parks, and that puts a blight on the local government, local community, municipality, whatever it may be, and they see them and they don't want them there.
Yeah.
So then you have to deal with that regulation.
Sort of the difference between a slumlord versus a property management company, right?
Yeah.
Like they're connotatively quite different from each other.
They are, and you'll have some that are definitely slumlords.
Yeah.
But you also have those that require. In Central Florida is great with this. You know, kind of near the villages.
Yeah.
You also have these like immaculate mobile home communities that are in line with the villages. You know, that are in line. You have these older retired folks who came down from the north, want to invest in some property down here, even though they're not getting the property, they still own the home and they take great care of it.
Yeah.
And when you get clients like that, or you get tenants like that, you can't beat it. You want to keep them in there, and that's what mobile home parks offer, is long-term tenancies.
Yeah.
So that's why I say it's recession-proof. That's why I say it's a long-term investment, because when they own their home, they're more likely to stay. In an apartment complex, or even a house, somebody can just turn the keys in today and walk away, even though there's a lease.
Right.
But with mobile home parks,
there's a serious investment there.
There's a real investment.
You're putting roots down in that park.
That's the idea.
Yeah.
That's the idea behind it. They own the home. They're not going to walk away from it. And if they do walk away from it, then you can gain possession as a landlord or as a property owner. You can gain possession of that home through the proper protocols, which is the abandoned property process, and then you can resell that home, which affords you the opportunity to collect any lost income from that unit, which you don't really see in apartments, which you don't really see in standard landlord-tenant.
Yeah, it is quite different.
Law,
Yeah, with typical landlord-tenant scenarios, I mean, when you're talking about personal property of a tenant, you're talking about typically trash that they left behind.
Absolutely.
Every now and then you have a vehicle left on the property, you know, so you got to deal with that. But it's very unlike the mobile home, where you actually have an asset sitting on your property.
It's a huge asset.
So following that statute, 715 allows you to actually potentially own it if the tenant doesn't want it.
If the tenant doesn't want it, well, you have to go through that process, which includes a potential auction at the end of the process. But if nobody shows up for the auction or doesn't bid, and as I said, the bidding allows you, hey, we're going to set it at unpaid rent, any court costs, attorney's fees, the cost to advertise for this abandoned property, any administrative costs, and that's where we start the bidding, and that affords the landlord the opportunity to collect all that money that he's lost or she's lost.
Almost like having a secured loan in a sense.
Yeah.
Like, there's my collateral. Yeah.
Yeah, and a lot of these mobile home parks, speaking of loans, will work with tenants, and they do a rent-to-own situation.
I was going to actually ask about that, the rent-to-own, because that seems to be the scenario where that actually is a much more likely prospect.
Yeah, because the homes don't cost as much. You're not looking at a $200,000, $300,000 home that I'm going to charge you $2,000, $3,000 a month in a rent-to-own scenario, just for you to potentially purchase the home after 30 years?
Yeah.
This is a typically $10,000, $15,000, $20,000 rent-to-own situation.
Yeah.
So we're going to charge them their lot fee, and then we're going to charge them this rent on top of it, which will typically average out to about the same thing you're getting for an apartment.
Yeah.
But they own the home.
Yeah.
So we lose that overhead. We lose that maintenance overhead as a landlord.
Yeah.
Which is really exciting for most investors. I don't want to have to fix up a
plumbing
property
and everything else.
Yeah, plumbing, roof. Heck, a hurricane comes through.
Flooring,
I don't want to have to replace an entire home. Well, you don't have to. It's up to the homeowner.
Now we see people come to us with purchase agreements that are basically written on a napkin, right? I mean, like they're handwritten out. There's basically no terms, except for here's the price. Speak to that. Give a 2-minute little education for those that are thinking that they're going to do something like that.
Don't.
Yeah.
Don't. It's just a one word. Don't do it like that. Have somebody look it over.
Yeah.
Have us look it over.
Or draft it, for that matter.
Or draft it, yeah. Look over the agreement, draft the agreement. You need to put a lot of terms in any contract. I had, in my time, I also did some side work for an insurance brokerage company and became a licensed insurance agent in the state of Florida. No longer maintain that license, but I had it at one point in time. Reviewing contracts. I reviewed so many business contracts, software as a service, companies trying to contract their services out with some of these larger companies, Amazon, Microsoft, just all these big companies, so I gained that experience in reviewing these business contracts, and they are in depth.
Yep.
And there's a reason they're in depth.
Yep.
And even for purchase of property, real or personal, you want to have all the terms in there that you can get to protect yourself, and the tenant or the purchaser also wants to have those terms in there because it protects them.
Yeah.
But, as a landlord, obviously you have more leverage in these negotiations. So, we write it out to benefit our client the best.
Well, and just to be clear, because I know there's somebody out there thinking, well, if the lot tenant stops paying on this purchase agreement, I'm just going to evict them. I'm going to go through the eviction process.
But
they have a purchase agreement.
Yeah.
So that's different.
Yes.
You have to go through either foreclosure.
Yep.
Or potentially an ejectment. So,
yeah.
Have you seen that? I'm sure you have.
Oh, absolutely. We do replevant actions all the time, or did replevant actions all the time, and that's just essentially, hey, we're recouping our property, which is the mobile home, and we're foreclosing on this agreement and kicking the tenant out.
Yeah.
And you can go either route, but that's the benefit with this, because you can go either route. If they're not paying the rent, we can evict them from the property,
from the lot.
We don't have to necessarily go through the other action, because then we go through the abandoned property process at the end, and we recoup that. And if
so there's legal options.
There are legal options to that. I do advise going through both.
Right. Because if you happen to lose on one, you have a fail-safe, if you want to call that.
Correct. Yeah. And most of the time, and so we can kind of transition into the other statute.
Yeah, the RV.
Most of the time, these communities are mixed use. So you'll have RVs, you'll have mobile homes, you might even have apartments in the same property. I've definitely seen that with all three. But RVs are a little different, and there are regulations, and it's a 6-month threshold. We talked about this, transient guests.
Right.
Because there's transient is defined under 2 or 3 different statutes. When we're in these short-term hotels, it's what was the guidance on that?
Well, there's a 30-day. If you're over 30 days, there's a presumption that you're not transient.
Transient.
Yeah.
Whereas with RVs, it's 6 months.
Right? Yeah.
So if you stay longer than 6 months, you fall under the standard landlord-tenant action. But if you're under 6 months, you're considered a transient guest. And if I need to evict you or eject you from the property, I don't have to go through the courts.
Yeah.
All I have to do is send you a notice. It's a 24-hour notice. Call the sheriff up. The sheriff's deputy comes out and he removes you from the property.
Yeah.
That's the benefit to the RV park.
For sure.
But occupancy, obviously, there's the detriment. Is you're getting these short-term rentals.
Well, and the whole idea, because some people use these RV parks really to live. That's where they're living.
100%.
And so when the statute actually talks about how if there is an actual intent for them to be a sole residence, that's their sole residence, then you lose the transient status. Yeah. And now you've got to go in another landlord-tenant status.
Correct.
Yeah.
Which doesn't really affect us too much. It's just a different statute. It's just a different route to eventual eviction, if that's the route we'll go.
Yep.
Or different guidance regarding the lease. But it's still a lease. You still haven't signed a lease. Even under the transient, even under the 6 months, you haven't signed a 6-month lease to show that intent.
Yep.
We say, no. He's not here long term.
Yeah.
He's here for less than 6 months.
Right.
That way, we still fall under that transient guideline.
Whenever people come in and they have a situation, many times, they think that a certain action is, of course, they always use eviction, right? That the word is like sort of a universal word for get this person out of my property.
Yep.
And so when we consult them, part of our job here is just to simply look at which statute applies so that we can then give the proper notice to that person to get them out.
Yep. That's exactly it. And as I mentioned before with the mobile home parks, some of them do fall under Chapter 83. Some of them fall under 723. Sometimes you have an RV that falls under 723.
Yeah.
Sometimes it falls under 83. Sometimes it falls under 513, which is the RV statute.
I have some friends that are investors in RV parks, and they're buying them across the country, and really even trying internationally. Right? It's a huge business.
Huge market. Yeah, it's blowing up.
Yeah. So what is, in your experience, what's the golden nugget for those guys?
What's the goal?
Yeah.
What's the draw for these guys?
Yeah.
Well, it's the same. I own a piece of property. It's just sitting there. it has all these different hookups. Yeah, there are regulations, and that's local government regulations, code enforcement or fire safety, whatever it may be. But it's just property. I don't have to develop anything.
Yeah.
The most I have to develop, as I said, is just these hookups: the electric hookup, the water hookup. Am I going to offer cable? Am I going to offer
playground for the kids?
Yeah. Am I located close to a body of water? That's huge.
Yeah. Lakes.
That's huge.
Ocean.
Because when people are traveling, and again, mostly we're in this retirement group,
Mecca.
the golden
Mecca of retirement here.
they're traveling across the country, and what's the draw? What's your draw? Okay,
Yep.
So I'm right next to the beach. We have several of them right down here.
We're looking at the water right over there.
Right down here. several communities, several RV communities, and it's money.
Yeah.
I have to pay the property taxes on it every year, right? Other than that, what am I paying? I'm paying utilities, but my overhead is so low.
Yeah.
And that's the draw.
Right.
I charge them rent by the night.
Yeah.
Or by the week. I offer, different things like that, different routes to tenancy, and I just make money.
Yeah.
I don't have that overhead again that the apartments have.
That sort of true passive income model is powerful.
That's all it is.
Yeah.
It's just me sitting back collecting money. It's long term.
And at the end of the day, and we're attorneys, so here we are. So I saw a Facebook post this morning that I'm going to respond to it later today.
Yeah.
It's in a like a landlord group on Facebook.
Oh, okay.
And
very interesting.
Yeah, the property owner said, "Hey, is there at some point that I should just not worry about having insurance, property insurance, liability insurance?" And I already saw there's like 60 comments on it. Who knows what was said? But I'm like, you need insurance.
Absolutely.
Right?
100%.
Unless you can self-insure, right? If you can self-insure, I guess, but you better have a large reserve for self-insuring.
Yeah, it's so important. We get so many of these nuisance lawsuits, as we call them as attorneys, and it's just people suing you for getting injured on your property.
Yeah.
So how do we mitigate that risk? Kind of going back to that, it's signage, it's in your lease, having in your lease,
Yep.
or maybe making them sign a waiver for any injuries caused by some of these different things. But yeah, you definitely need insurance.
Yeah.
Insurance protects you. That's what it's there for.
It's expensive, but it's worth what it does.
Yeah, it's definitely necessary. And we're in the state of Florida. Hurricanes exist.
Yeah.
They come through, they destroy your property.
Yeah.
And unless you can rebuild yourself,
Yeah.
have the insurance.
Pretty risky. Pretty risky.
Absolutely. And kind of going on that too with the kind of nuisance claims is these attractive nuisance is what they're called.
Yeah.
And that's having a playground or having a river or body of water nearby.
Right.
Attracts kids to your property, children who aren't necessarily residents or tenants, or you have no relationship with them, but because they're there, they're going to attract the children.
Yeah.
And then you are liable or could be found liable for those injuries, for any injuries. I think you were mentioning before, a situation with an apartment complex in a river.
Yeah, in Tampa. Yeah. A child, I think they were actually close to teenage or maybe even teenage years, mental disability. The river was on the property edge of the apartment.
Open, I assume?
Open.
Probably no signage, no...
I can't remember if there was signage, but I think the person couldn't appreciate the danger. Yeah. Ended up, unfortunately, drowning.
It's unfortunate,
and so, obviously, the litigation ensued, and they had to deal with that. So, yeah, if you're near water, playgrounds, pools, anything that could attract children onto your property is potential liability.
Yeah, risk management is a big part of what I've done in the past. I'm sure you do as well as an attorney for property managers and for property owners. It's big, it's huge. We need to look at these things and we need to say, hey, you have a pool, mitigate your risk, put a fence around it. Have key card access to it.
Yep.
You can only get in if you live here.
Yeah.
Same thing with playgrounds. Put a fence around it.
Yep.
If you have a body of water, put signage up.
Yep.
We're not responsible.
Video surveillance
Surveillance as well. just letting the tenants know, or letting any sort of unauthorized trespasser know that we're not responsible for any injuries caused. If you're not supposed to be here, you're not supposed to be here.
Yeah.
With RV communities, that's signing a waiver. With more traditional landlord-tenant, whether it's mobile home or apartments or houses, it's putting something in the lease.
Yeah.
Obviously, we can't mitigate all risks. We can't limit all liability.
Yeah.
We wish we could.
Yeah. Yeah.
But that's, again, why they're called nuisance claims.
Yeah.
Because people just sue to sue. I saw a lady in Target kick around a puddle of water that she saw on the floor and then just dropped to her knees.
Yeah.
And my wife and I both knew.
Yeah.
Hey, she's trying to get a payout. She's trying to get cash out. And Target has all the cameras, but it doesn't matter.
Yeah.
Unless nobody's willing to take her case, which hopefully these personal injury firms will filter these out.
Well, or they may encourage them, quite frankly.
Yeah.
Let's be honest about that.
You don't know. You never know. But, ever since I graduated law school, anytime I go in a business or building, or heck, just walking down the street, I can see liability. I see those risks.
Yeah. That's why people don't like conversing with attorneys. We're like, hey, can you just leave that out of the conversation? We don't want to talk about that.
No, and I don't even like doing it, to be honest with you. And in that time in Target, I just walked away. I said, I'm not getting involved in this.
Yeah.
I said, no, exactly. I'm not being a witness. I'm not going to court.
They would love to have you as a witness, though, if you knew that.
Absolutely, they would. But most of these nuisance claims settle. Unfortunately, as a former insurance agent, I can tell you that insurance companies just settle these. Mm-hmm. They say, well, $5,000, make it go away. Yeah. And that's great for the liability issue, for having to go to court.
Yeah.
But what it's not great for is your premiums.
Right.
Because the more of these you get, and having worked, again, in-house counsel for a company, we had so many premise liability cases.
Right.
Some of them were nuisance, some of them were not.
Yeah.
Some of them were legitimate.
Yeah.
It's maintaining, your property is important.
Yeah.
You can't mitigate those risks.
Yeah.
If you don't maintain your property, if somebody comes to you and says, hey, your stairs are broken, fix the stairs.
Yep.
That's the solution.
Yeah, there's no option there.
There's no option.
Yeah, the balcony railing is a little loose.
Well,
I'll try to get a guy on that. No, it's like
get a guy on it. Yeah, get a guy on it.
You have your cell phone, call them right now.
And document everything.
Yeah.
Document. If you end up calling me at any time, I'm going to tell you document. Yeah. And the reason behind that is, okay, well, the tenant came to me and said that the balcony railing is loose. So I told him, stay off the balcony. We'll have somebody there tomorrow. Mm-hmm.
Tape it off even.
That's mitigation.
Yeah.
I told him not to go back out there. Yeah. And they went back out there.
Yeah. But if someone who is there, you didn't tell that person directly because you didn't have a conversation with them. So it's like, well, what other steps did you take?
Yeah.
Blocking it off. Do not enter.
Yeah. Absolutely.
Right? Yeah.
Absolutely.
All these things.
And you have a right as a landlord to enter the property if it's an emergency.
If it's an emergency, do it now.
Yeah.
Yeah.
And that probably rises to the level of emergency. If they're throwing a party or something and they say the railing's loose, well, I need to get in there right now because I don't need any drunk college kids falling off the balcony.
I've seen those cases.
It happens.
Party goers.
There's a reason I said it the way I said it.
Yeah.
And it happens at hotels. I heard about it in Panama City so many times. Panama City was a spring break capital.
Capital. Yeah. Have a good old time.
Yeah. So
many. Just try to stay safe.
Yeah. But they fall off balconies.
Oh man, this is conversation you could just have all day long.
Absolutely.
So at the end of the day, insurance reduction of liability. Of course, like for multifamily, the newly passed statute 768.0706, which is the security measures multifamily owners can take to give a presumption of no liability. Wow, that's pretty powerful.
That is very powerful.
But you've got to follow those steps.
Yeah, and not every state has that, and I'll tell you that.
I think we might be the first. Might be the first.
I think there's a couple others that have similar guidelines to help mitigate liability.
Yeah.
But again, it doesn't stop people from suing.
No.
It will never stop people from suing. The best you can do, though, is say, hey, but then you get to go to court and you get to say, hey, we followed all the steps.
Yep.
They didn't listen. It's their responsibility. In Florida, a few years back, switched from a pure comparative fault to modified comparative fault. What does that mean for you? In any negligence action, you have to be more than 50% at fault for them to prevail on damages. However, you have to go through a whole lawsuit before the jury decides or judge decides what percentage of fault.
Yeah, because only the fact finder can determine percentage.
Yeah.
It's a fact issue. So you're never going to win on summary judgment.
Yeah.
Right?
No.
Probably.
Well, yeah, probably.
Yeah,
let's say probably. Yeah.
Right. We never say always. We never say that.
You probably could if it's clear that you were only 10% at fault in the lawsuit, in the claim. But yeah, when Florida switched, I was very, very happy, very excited to see that. Just because before we were pure comparative, which meant no matter what percentage of fault you were, you had to pay that amount of the damages. Yeah. So if you were 1% at fault and the damages were awarded at $10 million, you're still paying $100,000. Yeah. If it's $1 million, you're paying what, 10,000 or 1,000, whatever. I'm not a math expert.
Yeah. But, where's your phone?
but that was beneficial, and that was a step that the governor took, and the legislature took to help with these insurance costs, these high insurance costs in the state of Florida. They said, well, if we reduce negligence from 4 years, from a 4-year statute of limitations down to 2 years, changes from pure comparative to modified comparative, insurance rates will go down because there won't be as many lawsuits. Yep. The problem is again, as I said, you have to go through the lawsuit to get to the percentage of fault. Before that.
Well, it just it's putting pressure on plaintiffs' attorneys to get these cases filed. So you actually have probably an increase of cases filed
initially.
And of course, the insurance defense has to deal with that.
Insurance defense does have to deal with it. It does also put a lot of pressure on these personal injury attorneys to kind of fact find before they file a lawsuit
and choose your cases wisely.
Exactly. So there's more of a filtration process in that, and they're looking at them and saying, well, you were probably more at fault than we were. We don't really feel comfortable filing it. They may send it to another, a solo practitioner who's more than willing to take those cases and just, I'll send a demand to see what happens.
Let's see what happens.
And a lot of attorneys, unfortunately, take that approach. But it doesn't mean they're wrong. They're just doing their due diligence.
Well, I'm sure you've seen this. We'll try to wrap this up here in just a minute. But I've seen an increase in tenants finding attorneys. It used to be that really landlords kind of assumed, well, the chances of them getting an attorney are slim. I can't really say that anymore. And I tell my clients and any landlord that they very well could find any attorney to represent them, and maybe not even at a cost. Some of them are pro bono. Some of them take contingency if they think there's damages. So don't presume that you think you have leverage just because they may not get an attorney. They very well could.
Yeah, and it's not, as Tim mentioned, pro bono, we have legal services, even for these eviction actions. Legal services is stepping in. But the statutes, all 3 statutes allow for attorney's fees.
Right. So there's an incentive to take those cases.
Yeah, absolutely. If you put in the work and you put in the effort, and I've seen legal services for me, I don't know if they've done this with you, they prevail in a case and they say, well, instead of us collecting on attorney's fees, how about you just forgive the rent, or you forgive, you negotiate a move-out date. So I
haven't had them do that because they've never prevailed on me before. But just kidding. I'm not trying. No, but that's actually a good idea. I mean, they're helping their clients out.
Because they don't get any reward.
They're pro bono.
They get paid off grants. They get grants from the state of Florida. And from other attorneys. I don't know if you got the letter from the Florida Bar. I got the letter more recently that said, hey, do you want to donate to legal services? My answer is no, because...
might be a conflict of interest, actually, for us. We see them so often.
But they're great. They're great attorneys.
They are. They are good
for and that's why it's important, because most of the time, if they are going to prevail. It's a procedural issue that we recognized before, but it's typically on a notice that I didn't draft. That my clients drafted.
Very common.
I have to help mitigate that.
We start over.
We started over.
We start over. Just do it the right way.
But once the attorney's representing the tenant,
Kind of stuck with that case. They're not going to let you dismiss it without a result.
yeah, without some sort of attorney's fees.
Yeah, that's right.
Attached to it.
Yeah.
So send your notices our way. And
Yeah, so let us look at them. That's right. That's
and we'll
right.
review those for you.
Yeah.
Yeah. So it's
All
important.
good stuff.
Yep.
You've articulated these things very well for the audience here. I greatly appreciate it. Mark, we've loved having you at the office, and you're doing a great job. So I'm really glad you're a part of it.
Thank you,
Yeah.
Tim. I've enjoyed being here. I enjoy working with you in the future.
Yeah, absolutely. Well, we'll do this again on some future podcasts. Pick some interesting topics. If you have a topic you want us to talk about, hey, email me.
Oh,
Say, hey, let's talk about this topic. That'd be great.
I like
Tim
that.
at pmlawsolutions.com is my email address. If you are a landlord or investor or apartment company, we can help you. We do a lot of work for a lot of landlords around Florida, and love to talk to you as well. So thank you for listening, everybody, and we'll see you on the next show. Have a good one.